Hi, and thanks for tuning in. I'm Dustin Saldarriaga, an immigration attorney with Scott Legal PC in New York City, and we hope you're enjoying a happy and healthy start to 2022. Today we're going to be talking about an interesting topic. It's one of the few situations in which a child born on U.S. soil is not considered a U.S. citizen. That's the case for children who are born to foreign diplomatic officers in the United States. In this video, we'll get into more detail on why this rule exists and how diplomats might navigate it if they want their children to be permanent residents and, eventually, citizens of the United States. As many of you are probably aware, most children born in the U.S. are U.S. citizens at birth. One of the only exceptions to this rule is that children born in the U.S. to foreign diplomatic officers do not receive U.S. citizenship at birth. This is because although the U.S. Constitution says very little about immigration generally, the 14th Amendment does say that, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. A child born to a foreign diplomat on U.S. soil is clearly born in the United States, but they are not subject to the jurisdiction of the United States. As a result, a child born in the U.S. to a parent who is a diplomatic officer is not a U.S. citizen at birth. Keep in mind that not all diplomats have full diplomatic immunity in the U.S. In fact, it's a minority of diplomats who have full immunity and whose children therefore are not born as U.S. citizens. So before concluding whether or not your child will receive U.S. citizenship at birth, it's important to first confirm that you are in fact a foreign diplomatic officer for immigration purposes. Among those who are not considered foreign diplomatic officers for purposes of U.S. immigration law are the following: consular officials and other foreign government employees with limited or no diplomatic immunity, employees of foreign diplomatic missions. These employees are listed on the Department of State's so-called whitelist, and employees of foreign diplomatic missions accredited to the United Nations. Also, if either parent of the child born on U.S. soil is a U.S. citizen or a non-citizen U.S. national, the child is born subject to the jurisdiction of the United States. That means that if one of the child's parents is a U.S. citizen or U.S. national, the child born on U.S. soil would acquire citizenship at birth even if the other parent was a foreign diplomatic officer at the time of the child's birth. So then, who is a foreign diplomatic officer? Foreign diplomatic officers, those whose children do not receive U.S. citizenship even if born on U.S. soil, are listed in the U.S. Department of State's Blue List, or the United Nations Blue Book. These lists give the names of those individuals who serve foreign states and international organizations and, as such, are generally immune from any form of arrest or detention. The lists include, for example, ambassadors, ministers, and those with diplomatic status and immunities who work for the United Nations. As mentioned earlier in the video, an important first step when determining whether a diplomat's child received U.S. citizenship at birth is to learn whether the parent did in fact appear on the Blue List or in the Blue Book at the time of the child's birth. The current edition of the Blue List is available online, as are archived versions going back to around 1997. We'll include a link to these lists in the description below. You can also reach out to the Office of the Chief of Protocol at the Department of State for additional help. The UN also makes the Blue Book available online. Archived versions of the UN Blue Book are available at the UN Library in New York City. We'll share a link to their contact information in the description below as well. So let's say that you have confirmed that you are a foreign diplomatic officer and your child is born in the U.S. We've already established that they would not be a U.S. citizen at birth. However, they can become a lawful permanent resident and, at the age of 18, and if they satisfy a few requirements, they can pursue U.S. citizenship. So let's take a look at that process. The registration of a diplomat's child as a permanent resident of the U.S. is voluntary, not automatic. So the parent, or the child, if they're old enough, must actually take action to register as a permanent resident. To qualify, the child must be physically present in the U.S. and must have maintained continuous residence there. This means that the U.S. must have remained the child's primary home since their birth. Continuous residence is not the same as continuous physical presence in the United States, which is not required. For example, even if the child attended school in their parents' home country, they might still have maintained continuous residence in the U.S. The child's parent can sign the application forms on behalf of the child, so it is possible to register an infant for lawful permanent resident status. The child or their parent would file Form I-485 with the required fee and supporting documents such as their birth certificate and proof of continuous residence in the U.S. The applicant or their parent would also need to waive any privileges and immunities they received as a result of the parent's diplomatic status. They can do this by filing Form I-508. If the application for permanent resident status is approved, the date of permanent residence will be the individual's date of birth. A child born in the U.S. to a foreign diplomatic officer must wait until they turn 18 before applying to naturalize, and thus to become a U.S. citizen. The child would need to have maintained their lawful permanent resident status and meet all other requirements in order to naturalize. This means that the individual must maintain continuous residence in the U.S. from birth until they're at least 18 years old if they are to become U.S. citizens as a child of a diplomat. However, depending on the individual's age and the amount of time they've had continuous residence in the U.S. at the time they register as a lawful permanent resident, for some, they might be able to become a naturalized citizen not long thereafter. We hope you found this video helpful. If you did, please click the thumbs up and subscribe buttons below to stay updated on future videos about visa options and travel to the U.S. Thank you for watching.